Imagine you open your phone, and a site is right there. Not just controversial, not just edgy, but material that crosses a legal line, content that praises terrorism, encourages violence, or tries to radicalize people. So what happens next? Because in the UK, a website doesn't get shut down by one big red button. It happens through a chain of legal powers, regulators, police units, platform duties, hosting decisions, and sometimes court orders. In this video, we're going step by step through the real, lawful process the UK uses to get extremist and terrorist material taken down, and, when needed, blocked. No myths, no politics, no panic, just the mechanics. What triggers action? Who gets involved? What takedown actually means? And what the limits are. Let's start with the key idea that underpins everything. Illegal content is treated very differently from harmful content. First, language matters. In everyday speech, people say extremist content to mean anything from hateful propaganda to conspiracy politics. But the legal system cares about something more precise. Is it terrorism related? Is it otherwise illegal? And which offence exactly does it map to? In practice, the most urgent and strongest takedown routes are used for material tied to terrorism, especially content that encourages acts of terrorism, promotes a prescribed organisation, or distributes terrorist publications. If it's not terrorism, it might still be illegal under other laws, incitement to violence, harassment, certain hate offences. But the pathway can change, the urgency can change. So when the UK moves to shut something down, the first decision is not, do we dislike this? Is it illegal? Which law applies? Who has jurisdiction? And what tool is proportionate? Most takedowns begin with detection, and there are three main routes. First, public reporting. Someone sees material online and reports it through official channels. Second, platform detection. Large services run automated systems and human moderation. They detect patterns, user reports, re-uploads, network behaviour linked to extremist propaganda. Third, intelligence and policing. Counter-terror police and intelligence agencies may identify material during investigations. But here's what people often miss. A report is not a verdict. A report triggers assessment. And assessment is where specialist capability comes in. In the UK, that includes a national policing unit focused on terrorist material online. Once content is flagged, it goes to triage. At that point, specialists ask a simple but critical question. Does this content cross a legal threshold? This is not a vibe check. It's an evidence and law check. They examine what is actually being said or shown. Is it praising terrorist acts? Is it encouraging violence? Is it promoting a prescribed organisation? Is it distributing material designed to recruit or radicalise? Context matters. The same image can be legal in a news report, illegal in propaganda, ambiguous in satire. They also look at where the content is hosted, because jurisdiction determines what can happen next. If it's hosted in the UK, action can be relatively fast. If it's overseas, the route becomes more complex. Now we move to the mechanism most people imagine when they hear the phrase, shut down. In many cases, the fastest result comes from notice and takedown. A competent authority contacts a platform or hosting provider and says, this material appears to be unlawful under UK law. Remove it. If it's on a major platform, there are dedicated law enforcement channels. Posts can be removed, accounts suspended, channels terminated, sometimes within hours. If it's a standalone website, the process becomes more infrastructure-based. Who is the hosting company? Who registered the domain? Where is the server physically located? Who controls it? If the host is cooperative and within jurisdiction, service can be suspended, hosting terminated, access removed. But here's the key distinction. Taking down content is not the same as arresting someone. Takedown reduces harm quickly. Investigation addresses accountability. When content may be linked to terrorism offences, the system often has to do two things at once: reduce harm and preserve evidence. Because once content disappears, the evidential trail can disappear with it. Investigators may lawfully seek account identifiers, upload logs, timestamps, IP data where authorised, links between accounts, communication trails tied to dissemination. Access to that data is governed by legal safeguards, authorization processes, oversight, not a casual request. And the outcome varies. Some cases lead to prosecution, some to disruption measures, some to safeguarding interventions, especially if young people are involved. Some don't meet the threshold and go no further. But what if the site keeps reappearing, hosted overseas, ignoring requests? That's when another tool may be considered: blocking. Blocking does not delete content from the global internet. It restricts access from within UK networks that implement the block. It's usually considered when content is clearly unlawful. Other routes have failed, and the harm is serious enough to justify intervention. Blocking is not the first option. It's typically a later stage measure, and it can be subject to legal scrutiny and review. In recent years, another layer has been added: the online safety framework. Under this system, in-scope services have legal duties relating to illegal content. That changes incentives. It's no longer just, will the platform voluntarily remove this? It becomes, what are the platform's statutory obligations, and what happens if it fails to meet them? The regulator can assess risk, scrutinise systems, require improvements, and in serious cases, pursue enforcement action. That does not replace policing. It strengthens the expectation that services proactively manage illegal material. But even with regulation, there are limits. The UK cannot treat unpopular views as illegal by default, so there are guardrails, legality tests, proportionality, oversight, appeal routes, judicial scrutiny where relevant. Because the hard cases are rarely obvious propaganda pages. They are the grey areas: news reporting, documentary footage, academic discussion, satire, political speech. A mature system has to distinguish between reporting on terrorism and recruiting for it, between offensive speech and criminal encouragement, between removal that prevents harm and action that would chill lawful debate. So when you hear that the UK shut down an extremist website, what you're often seeing is the final stage of a much longer chain: report, assessment, takedown request, evidence handling, regulatory pressure, and sometimes court-backed blocking. It isn't a single switch, it's a layered system, designed to reduce harm, enforce the law, and operate within democratic constraints. If you want a follow-up, the next logical question is this: what happens to the person behind the site? Because removing content is one thing. Investigating, disrupting, or prosecuting the individual behind it is another story entirely. If you found this useful, subscribe for more UK-focused explainers on how the system actually works, quietly, legally, and in detail. And remember, if you see content online that appears to cross the line into terrorism or incitement, use official reporting channels. Don't share it, don't amplify it, and don't engage with it. Thanks for watching.